organizations alike. Our goal is to foster a safe, respectful, and inclusive work environment for everyone. Sexual harassment is not just a personal issue, it's a workplace issue that can have far-reaching impacts on employee morale, productivity, and overall organizational culture. Today, our eminent guest will guide us through the effective strategies for prevention, including both proactive and reactive measures. Firstly, I invite respected Additional Commissioner of Income Tax, Srimati Veni Raj Ma'am, for the welcome address.
Good evening all, and welcome to the workshop on prevention of sexual harassment in workspace. It is a very pertinent topic in the current scenario. Rabindranath Tagore is the only one Nobel laureate from India. He has written in his classic Gitanjali, where the mind is without fear and where the head is held high. Into that heaven, my father, let my country awake. This was the prayer he made in 1930s, and to which heaven our country has gone now. On August 9th, in the same Calcutta where Rabindranath Tagore was born, our fellow sister, a young doctor with lots of dreams and aspirations, was brutally raped and murdered in her workspace. There lies the relevance of today's topic. India is having an alarmingly growing rate of sexual violence. Every 15 minutes, one women rape case is reported. That means unreported cases are more. And almost 85 to 90 rape cases happen in a year in India. So there lies the relevance of this topic. Moreover, the conviction rate is just around 27% in India, whereas it is more than 60 to 65% in advanced countries. In this occasion, to set an introduction, let me invite your kind attention to two iconic fighters as far as the POSH Act in India is concerned. Because in our childhood days, we believe that seeing is believing. When we see something, we will retain it. So I will invite your attention to this iconic fighter. She was Banwari Devi. She was 31-year-old and she was working as a friend in the Rajasthan Women Development Program. Her mandate of her job was to educate women about infanticide, against child marriage, dowry and all. In her daily work, she came to know that one 9-month-old baby was getting married. I'm right, 9-month-old, not 9-year-old baby. So this 9-month-old baby, she tried to prevent the marriage of that 9-month-old baby in Rajasthan. And for that fight against this atrocity, she was raped by the father of that 9-month-old baby and his friends. She is the iconic fighter behind this POSH Act. So we should remember that this unlettered lady was the trigger for this prevention of sexual harassment case in India. And another iconic lady, and the sorry state of this lady is that now she is around 64 or 65 years old and still that case is pending in the court. And only one hearing has happened in 33 years after this atrocity has happened. There lies the relevance of this topic. And another lady is Naina Kapoor. She is the person who took the initiative to file a public interest litigation in the Supreme Court when the Rajasthan High Court acquitted all the rapists in the case of Banwari Devi. And two alleged people have passed away during the trial period, and till now no progress has happened in that case, though the Vishaga judgment has come and the POSH Act has come. This Naina Kapoor, when this Rajasthan judgment came, she traveled across India, interacting with women from grassroots levels. And she asked a basic question to all the women: what is access to justice mean to you? And all women, irrespective of caste, creed, or financial status, mentioned it means having my sense of self intact. That is the very basic demand of any woman, be it in the workspace or in the private space. So let us begin today's workshop with an idea in mind that it is not act which is needed, but it is the action from our end is needed. So I enter my proposed duty today. I welcome Honorable Principal Chief Commissioner Preeti Garg Madam to this August occasion. Madam has been a motivation behind us to conduct such programs which involve discussion and involving our officials and officers. So I welcome Madam to this workshop. And I take this opportunity to welcome Uma Devi Madam, Principal Commissioner of Income Tax, Uma Venkadeshan Madam, Principal Commissioner of Income Tax, and is a chairperson of ICC at Kochi and Trivandrum. Now I take this opportunity to welcome Sanal Kumar ji, and leading advocate in High Court, and he has been the legal officer in CRPF for almost 13 years, and now he is practicing in High Court. He has a rich experience of handling POSH cases in High Court and many other judicial forums. So I hope that this will be a very fruitful discussion. I welcome Sri Sanal Kumar to this evening. Thank you.
Thank you, ma'am. Now I invite respected Principal Chief Commissioner of Income Tax, Kerala, Srimati Preeti Garg ma'am, to say a few words.
Good afternoon to all. I'm very happy that this program is being organized today, the seminar on prevention of sexual harassment at workplace. As Veni just laid out, it is a very relevant topic today. Day in, day out, women employees are subject to sexual harassment at their workplace. As also most of us know that it is now more than 10 years since the POSH Act of 2013 was enacted, which in turn was 16 years after the Vishaka guidelines and the case of Bhavari Devi were brought to the notice of the Supreme Court, and they had laid down the Vishaka guidelines. Prior to this, the only redressal was in what was earlier IPC, the Indian Penal Code. Other than that, there was no other action which a woman who was subjected to sexual harassment at workplace could resort to. So in that aspect, we have come a long way. Internal complaints committees have been set up. Some cases have also been instituted in various departments. But we still have a long way to go. Departments, organizations, and courts are still struggling with meting out justice. This happens on account of lack of evidence and the lack of will on the part of witnesses to come forward. The big issue, I feel, is also lies in acknowledging that sexual harassment has taken place. It is the duty of each one of us, men and women alike, to see that women are safe at their workplace in our department. Sexual harassment of women, even more particularly those in a lower position in hierarchy and therefore weaker in terms of the power or authority they possess, by those in a commanding position cannot be tolerated at all, and we as an organization must show that we have a zero tolerance attitude towards this. Little disappointed to see less men attending this seminar today. While it is to do about women's safety at workplace, it is also about the role men and women alike would play as colleagues and supervisory officers, as ICC members, etc., to ensure the implementation of the act, the law. Today's seminar, the main lecture by our chief guest, Shri Sanil Kumar ji, hopes to bring home some of the salient features of the POSH Act and the responsibilities and duties of all concerned. What constitutes an offense? Who is the accused person? What is the redressal mechanism? What is a preliminary investigation? What is a detailed inquiry? Who is authorized to conduct the inquiry? The rights of the aggrieved woman as well as that of the accused, I hope would be covered in this talk today. The speaker, as some of us know, is renowned in his commitment to similar causes in the course of his practice as a lawyer with the Kerala High Court. We should all benefit from this and contribute to making our workplace better and safer for our women colleagues, our women contingent staff, our women daily wage workers, and also for any women visiting our office for any office work or any work. I hope this will be useful for all of us. Thank you.
Thank you, ma'am. Today, we are honored to have with us Mr. Sanil Kumar ji, who is a highly respected advocate at the High Court of Kerala and has 5 years of experience in dealing with service matters, especially departmental inquiry proceedings of central and state government employees and officers of All India service. Out of his 20 years of service in CISF, he has dealt with departmental inquiries and court cases for more than 15 years. He was in the court license cell of CISF from 2013 to 2019 at High Court and has advocated many cases for the department. He has conducted various cases in High Court of Kerala for victims or de facto complainants. He is also giving legal assistance for complainants in sexual harassment inquiries conducted by various departments. I welcome Sanil Kumar sir to please share his knowledge and experience on our today's topic. Sir.
Good afternoon, everybody. All the dignitaries on and up the dais, all officers of income tax, and all other staffs. I'm here for an interactive section of this act. I'm not giving a lecture in the type, but I'm starting with my experience and what are the required scenarios and what are the matters to be dealt under this act, how this act came to force, and what is meant by the complaint, and like. So first of all, I will take this opportunity that Sexual Harassment Act 2013 was enacted, as you all know, that after the judgment of the Supreme Court in Vishaga's case, that is in 1997. This is the second case wherein the Supreme Court has stepped into the shoes of the parliamentary legislation. Before that, in a caste verification committee case, that is Madhuri Patil versus State of Maharashtra, Supreme Court has formulated the guidelines for how a caste verification has to be done. Still, even after the states were formulated the caste verification committees and all, still many departments didn't know how to verify a caste verification certificate. Many are sending the certificate merely to the Tahsildar's office, and when getting a report from the Tahsildar's office that this caste verification certificate is not available, they are dismissing the employee from the service. Likewise, in the year 1997, when Vishaka case, when detailed guidelines were formulated by Supreme Court, it took another, what to say, up to the year 2013, the Parliament took time for formulating rules and regulations. Now, rules and regulations are there, Act is there, and also some of the departments have their own Act and rules. They incorporated certain disciplinary proceedings into that also. As for the All India Service Officers as well as the CCS conduct rule, they have made some amendments for formulating all this. I'll start with my talk that what formulates a complaint and all. There is a handbook by the Government of India. Many of know that 2015 handbook. It is available. Many guidelines are explained there also. So the section 2N and 2O of the part of this act defines sexual harassment. So as everybody knows that section 2N defines what is an act of sexual harassment. So apart from the 5.1, some other portions were incorporated through the directions of Supreme Court as well as other directives of the central ministries. First of all, what meant by a sexual harassment is defined. So sexual harassment includes any or one or more of the following acts or behavior, whether directly or by implication. Namely, so most of the women who are giving complaint, they need to identify what is an act contributing this act. Then only they can file a complaint. So physical contact and advances, demand or request for sexual favors, sexually colored remarks, showing any pornography or any other unwelcome physical, verbal, non-verbal conduct of a sexual nature. All these are defined under sexual harassment. Thereafter, another 5 incidents are also incorporated into the definition of sexual harassment, which is very important. The following circumstances, among other circumstances, if it occurs or present in the relation to or connected with any act or behavior of sexual harassment, may amount to sexual harassment. That is implied or explicit promise of preferential treatment in employment. This is an important thing. If somebody is getting a preferential treatment on the basis of some sexual advancement, that is implied or explicit promise of preferential treatment, this comes under sexual harassment. Secondly, implied or explicit threat of detrimental treatment in an employment. Suppose you are not succumbing to the threat and you are meeting out with the detrimental treatment in the employment, that is also comes under. Then third, implied or explicit threat about her present or future employment status, that you may be transferred or you may be sent on a temporary duty, etc. This also comes under this. Interference with her work or creating an intimidating or offensive or hostile work employment. If a lady staff is working very well, but an officer or a colleague is calling him into the chamber and telling that you are not doing this and that also amounting to this. And fifthly, humiliating treatment likely to affect her health or safety. So the government and the courts have taken care of all of the incidents to include this. So only thing is that by analyzing, understanding what is the sexual harassment, complaint has to be given in time. So as the madam was pointing out that most of the officers or their colleagues, so they are afraid of what will happen to me. If I am suppose I am submitting a complaint, then what will happen to me? So by threat of transfer or sending to temporary duties or by threat of disciplinary action, all the officers, some of them are not ready to give the complaint, even though there are specific guidelines that every officers and the complaint committee should promote them or give them reasonable belief that nothing will happen to you if a complaint is being preferred. Now another definition is important. What is a workplace? Many of them have important that all are working in an office. So they are having a question that what is the exact place for happening of this harassment, if at all. For the same, workplace is defined under this act. So sexual harassment, as you know, that it is not limited to any organization, any central government or state government. It even includes to a domestic worker also. So this definition covers everything. Workplace means any department, organization, undertaking, establishment, enterprise, institution, office, branch or unit which is established, owned, controlled or wholly or substantially financed by funds provided directly or indirectly by central government. Hospitals or nursing homes. Any sports, including sports institutes, including stadium, sport complex or competition game venue, whether residential or not, used for training, sports or other activities related to their athletics, persons are protected here. Then any place visited by the employees arising out or during the course of employment. This is an important point. Including transportation provided by the employer for undertaking such journey. Two are traveling together and such incidents are happened there, they can complain. And it can be seen that if two of the officers are there or they are in a guest house where they are deployed for same duty, this applies. And finally, another place, that is a dwelling place or a house, is also defined under these rules. So this dwelling place or a house is also defined because domestic workers also this act is applicable. So this dwelling place or house is later added, and even in some of the cases a dwelling place was stated to be a place for sexual harassment held by Rajasthan High Court. I will come to that point. Now many are unable to know that complaint committees are there in the office. Section 4 of the Act deal with constitution of internal complaint committee. It says that every employer of a workplace shall, by an order in writing, constitute a committee to be known as internal complaint committee. There is a difference between what is an internal committee and a local committee. So local committee means in all district headquarters where 10 or less persons are employed, even it is for a private employment, it is called as a local committee. It will be headed normally by a local headed officer. In Kerala, I have seen that district collectors are heading this local committee, and he also deploys committee members. And as far as more than 10 persons are employed, including the state and central government employees, this constitution of internal complaint committee is doing. So every employer of a workplace shall, by an order in writing, constitute a committee to be known as internal complaint committee. A presiding officer who shall be a woman employed at a senior level at workplace from amongst employees. So there can be 3 persons. Out of 2 should be ladies. That is preferable. Not less than 2 members from amongst employees, preferably committed to the cause of women or who have had experience in social work or have legal knowledge. This is not like the 2 employees, 2 ladies were office staff were constituted in the committee. That is not like that. The 2 members should be having their knowledge in the cause of women. 1 member from amongst a non-governmental organization. So we are also having a NGO membership in the committee, but Act says that 1 member from amongst a non-governmental organization or associations committed to the cause of women or a person familiar with issues relating to sexual harassment. This should be there. This is the constitution of the committee, and what are the qualifications on that. Then there is seniority of the chairperson. In a case it is held that Allahabad High Court, there is a doubt that whether a presiding officer of the committee can be a junior of the officer against whom the allegation is made. They said that in my opinion there is nothing in scheme of the section which requires the lady member to be senior in the rank of the officer against whom allegation of sexual harassment are brought. The language of section 4 of the Act only requires the lady member to the senior level. So seniority issue has been settled by Allahabad High Court. Now we will come to the point that there are after formation of the committee, when a person is giving a complaint in the formation of writing and all, I will come to later. Now there are inquiries by the complaint committee in 2 formations. First, Previously it was a direct inquiry, but now a preliminary inquiry has become a mandatory condition. As per section 9 of the act, the aggrieved woman or complaint is required to make a complaint within 3 months of the incident, and in the case there has been a series of incidents, 3 months of the last incident. So most important thing is that a written complaint has to be made. The complaint committee may, however, extend the time limit for reasons to be recorded in writing if it is satisfied that the circumstances were such which prevented the complainant from filing a complaint within the stipulated period, which is another 90 days. Now, on receipt of a complaint, what has to be done? On receipt of a complaint, facts of the allegation are required to be verified. This is called as a preliminary inquiry or fact finding inquiry or investigation. So this fact finding inquiry is different from what is known as a regular inquiry. So here it is in the form of a preliminary inquiry, which constitute a form that a prima facie case is held against the accused. Now, section 9 of the sexual harassment state about complaint of sexual harassment. So we require to understand that there should be a written complaint. Any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal committee if so constituted, or the local committee in the case it is so constituted, within the period of 3 months from the date of incident, and in the case of series of incident, within a period of 3 months from the date of last incident. Anyway, 3 months period is there, mandatory period. Provided that where such complaint cannot be made in writing, the presiding officer or any member of the internal committee or the chairperson or any member of the local committee, as the case may be, shall render all reasonable assistance to the woman making the complaint in writing. So it is mandatory that if a person, a woman is approached to the committee and she is unable to write the complaint on account of many reasons, the committee should assist her in preparing a written complaint. Written complaint is a mandate. It's a must thing for preferring a complaint. So where the aggrieved woman is unable to make a complaint on account of her physical or mental incapacity or death or otherwise, her legal heir or such other persons as may be prescribed may make a complaint under this section. Now, complaint is again defined. Where the aggrieved woman is unable to make a complaint on account of her physical incapacity, a complaint may be filed by her relative or friend, her co-worker, or an officer of the National Commission of Women or state, any person who has knowledge of the incident with the written consent of the aggrieved woman. Where the aggrieved woman is unable to make a complaint on the account of her mental incapacity, a complaint may be filed by then again her relative, friend, or a special educator, or a qualified psychiatrist or psychologist, or a guardian or authority under whose care she is receiving treatment or care, any person who has knowledge of the incident jointly with her relative or friend or a special educator or qualified psychiatrist or psychologist, guardian or authority under whose care she is receiving treatment or care. Where the aggrieved woman for any other reason is unable to make a complaint may be filed by any person who has knowledge of the incident with her written consent. Where the aggrieved woman is dead, a complaint may be filed by any other person. So it is to be remembered that even a person who suffered sexual harassment is died, still a complaint can be made. Now, inquiry into the complaint. As I earlier mentioned, there are two kinds of inquiries. First is preliminary inquiry. So preliminary inquiry is being conducted by the internal committee to bring out the facts, whether a prima facie case is against the accused person or not. And it is a preliminary inquiry is being conducted as per the laws laid down in departmental matters, or it can be a mere fact finding inquiry. So here the complaint is, the copy of the complaint has to be served to the complainant, to the accused party within 7 days. So he has to submit his written submissions, and statement can be also taken, and thereafter this complaint committee will form an opinion as to whether he is prima facie there is a case exists against him or not. Then this complaint committee shall submit the report to the disciplinary authority. This is one type of inquiry, that is preliminary inquiry. Secondly, suppose if there is no complaint or the complaint is not established in the preliminary inquiries, then the committee can recommend for no further action can be taken, and if there is a reason that preliminary inquiry find that a prima facie case is existed against other person, then they can recommend for further disciplinary action to the concerned disciplinary authority. Now what about the regular inquiry under this rule? So regular inquiry as per the CC's conduct rule, I am talking about the persons who are governed by CC's conduct rule. For all India officers there is separate proceedings. For all the departments, if they are having separate proceedings, that will be governed. So on the basis of the report received by the preliminary inquiry committee, preliminary inquiry investigation, then a charge sheet needs to be given to the delinquent officer, and normally the charge sheet has to be given and a representation has to be taken from him also. Then the normal inquiry will be conducted by this complaint committee only. So in the light of CCA rules, in the light of Proviso to 14.2, CC's conduct rule were also amended to incorporate the sections of sexual harassment also. On receipt of investigation report means that the preliminary inquiry conducted by the committee. The disciplinary authority should examine the report with a view to see as to whether a formal charge sheet needs to be issued to the charge officer. So charge sheet is to be drawn by or on behalf of the disciplinary authority. In case of disciplinary authority decides on that course, the charged officer should be given an opportunity of replying to the charge sheet. As per rule 14.5, a decision on conducting the inquiry has to be taken after consideration of the reply as well. That is the procedure to be conducted. Now inquiry stages, as you know that there will be examination, preliminary hearing of the charged official, and subsequently witnesses will be examined. The delinquent will be allowed to cross-examine the witnesses. He can also put for the defense witnesses, and finally a presenting officer who is appointed by the disciplinary authority to present his case will have to present his brief. That is brief of the presenting officer. This brief will be supplied to the delinquent officer, and thereafter what will happen is that on the representation received by against the PO's brief, then the inquiry report will be submitted by the committee. Apart from the submission of report, the committee has certain other powers to make representations. Normally the inquiry officer is not allowed to make any recommendation in this report. Here the function of the complaint committee acting as inquiry authority differs. So the complaint committee will also have the powers to recommend, to transfer the aggrieved woman or the charged officer to any other workplace, grant leave to the aggrieved woman up to a period of 3 months, to grant such other relief to the aggrieved woman as may be prescribed, deduct from the salary or wages of the charged officer such sum as it may consider appropriate to be paid to the aggrieved woman or to her legal heirs. Any amount outstanding at the time of a cessation of services of the charged officer due to retirement, death or otherwise may be recovered from his pensionary benefits, terminal benefits payable to the officer or his heirs. Such compensation will not amount to penalty under Rule 11 of CC's pension rules explanation -2 Rule 11 also. So finally, after receipt of this report, the inquiry, the disciplinary authority will provide a copy of the inquiry report to the officer concerned and also to the person who made the complaint. So if the officer, the delinquent, along with the delinquent, the person who made the complaint is not satisfied with the inquiry report, then she can prefer an appeal under Rule 18. Any person aggrieved from the recommendations made under subsection 2 or 13 of the under clause or non-implementation of the recommendation may prefer an appeal to the court or tribunal in accordance with the provisions of the rules applicable to the said person, or where no such service rules exist, then without prejudice to the provisions contained in any other law for the time being in force, the person aggrieved may prefer an appeal in such manner as may be prescribed. So there is a scope for appeal by the person suffered the sexual harassment act also. Now another important fact to be noted is that the inquiry proceedings should not be published. Prohibition of publication of making known contents of complaint and inquiry proceedings. The complaint committee should also remember that as per section 16 of the act, notwithstanding the RT Act 2005, information as regards identity and address of the aggrieved woman, respondent and witness inquiry proceedings, recommendations of the committee shall not be published or communicated or made known to the public, press or media in any manner, provided that information may be disseminated regarding the justice accorded to any victim of sexual harassment under the Act without disclosing the name, address, identity or any other particulars calculated to lead to the identification of the aggrieved woman and witnesses. So DOPT has made a number of office memorandums for this also to incorporate all this. Then penalty is there for publication of making known contents of the complaint and the inquiry process. Suppose a witness who participated in the inquiry is knowingly or unknowingly publishing what was in his deposition or the cross-examination of the opposite party, where any person entrusted with the duty to handle or deal with the complaint, inquiry or any other recommendations or action to be taken under the provisions of this Act contravenes the provisions of section 16, that is non-publication, he shall be liable for penalty in accordance with the provisions of the service rules applicable to the said person, or where no such service rules exist in such manner as may be prescribed. So there is punishment for revealing the contents of the inquiry and statements and all. And as part of the inquiry, the charged official can also be suspended. He can also be transferred. There are provisions to this effect also. There are special provisions to deal with the threat or intimidation of the officers also. As I have pointed out earlier also, where a complaint committee has not recommended any action against employee against whom the allegation have been made in the case of involving allegations of sexual harassment, the disciplinary authority shall supply a copy of the report of the complainant committee to the complainant. So complainant is eligible for getting a copy of the sexual harassment report. It is not like that after conducting an inquiry, the inquiry report will be provided to the delinquent employee. No, the officer or the person who alleged to have been suffered the sexual harassment is also eligible for a copy, and he or she can also make complaint against same. Appeal under the provision of Rule 18.1. So the representation shall be deemed to be an appeal under Section 18.1 of the Harassment of Women at Workplace Prevention of Act 2013. There are other duties of employees. Duties of employees, I will mention provisions regarding preparation of annual report. Then Rule 14 is there for sexual harassment of women workers. Prohibition redressal rules 2013 also. Now, many have raised a question that whether this sexual harassment is there any opposite parties belongs to same gender can make a complaint. In a ruling by the Rajasthan High Court, it is stated that yes, it can be done. And in another case, that is in a Calcutta High Court ruling, Malavika Bhattacharjee versus Internal Committee, Vivekananda College and others, where the same gender complaint is maintainable. So the persons belonging to same gender can also allege sexual harassment against the same gender persons. Now, Madam was telling and pointing out that even after from the years 2013, the Act is published, complaint committees rules were published and all, but still many departments are not following the procedures established in the Act and rules. So this has been dealt seriously by Supreme Court in a latest judgment, that is Nisha Priya Bhatia versus Union of India and others, and granted 1 lakh compensation for not conducting the inquiry within the time frame and also making other violation of the Act. Wherein Supreme Court in another recent judgment, that is Aleria Fernandez versus State of Goa and others, also has given directive to the departments what are the actions they have taken after completion or after incorporation of this Act, what are their what their officers have done to implement the Act in their office. So in each and every officers, it is another important point to be noted that many of the lady officers or lady staff, they are unable to know what is the procedure and how can I make an inquiry and a complaint. Suppose all these are happening during the course of employment or can be outside the employment, all of a sudden she is afraid of how to make a complaint. So the opposite party will be an officer of the higher grade. So all the people will get afraid of how can I make a complaint. So Government of India has also make an important step towards, that is she box. Ministry of Women and Child Development launched an online complaint management system titled Sexual Harassment Electronic Box, she box, on 24 July 2017 for registering complaints related to sexual harassment at workplace. The she box is an initiative to provide a platform to the women working or visiting any office or central government, central ministries, departments, public sector undertakings, autonomous bodies and institutions, etc., to file complaints related to sexual harassment at workplace under the Sexual Harassment of Women Act 13. Once a complaint is submitted to she box, it will be directly sent to the internal complaint committee of the concerned ministry, department, etc., having jurisdiction to inquire into the complaint. The she box also provides an opportunity to both of the complainant and the nodal administrative authority to monitor the progress of inquiry conducted by ICCs. The she box portal can be accessed in the link given also. I don't know whether the she box is implemented here or not. So features of she box is as under. She box is an online complaint management system for lodging complaints related to sexual harassment of women at workplace. The steps required for filing of complaint through she box can be downloaded from the link. There is a link also given. Any woman working or visiting any office of central government, central ministries, department, public sector undertaking can file complaint related to sexual harassment at workplace through this she box. Once a complaint is submitted to the she box, it will directly and send the complaint to the internal complaint committee automatically of the concerned ministry, department, etc., having jurisdiction. The internal committee will take action as prescribed under the Sexual Harassment of Women at Workplace in accordance with Act 2013 and update the status of the complaint through administrative login also. The status of complaint can be viewed at any time by pressing the tab View Status Your Complaint also. So this much have been done by the Government of India. Then duties of an employer is also given. It is an important part. So every government servant who is in charge of workplace shall take appropriate steps to prevent sexual harassment to any woman at workplace. So section 19 of the act deals with what are the responsibilities of officers also. Now section 19 says that duties of employer. Every employer shall provide a safe working employment at a workplace which shall include safety from the persons coming to the contact with the workplace also. Display at any conspicuous place in the workplace the penal consequences of sexual harassment and the order constituting the internal committee under subsection 1 of section 4. So there shall be a board showing constitution of the internal committee and the penal provisions of this act. Third, organize workshops and awareness programs that is being done. Provide necessary facilities to the internal committee or the local committee as the case may be for dealing with the complaint and conducting an inquiry. Assist in securing attendance of respondent and witnesses before the internal committee or the local committee as the case may be, and make available such information to the internal committee or the local committee as the case may be, as it may require having regard to the complaint made under subsection. Provide assistance to a woman if she so chooses to file a complaint in relation to the offence under Indian Penal Code or any other law for the time being in force. Cause to initiate action under the Indian Penal Code or any other law for the time being in force against the perpetrator, or if the aggrieved woman so desires, where the perpetrator is not an employee in the workplace at which the incident of sexual harassment took place. That is also included. Treat sexual harassment as a misconduct under the service rule, which is already incorporated in many of the rules also, and initiate action for such misconduct. Monitor the timely submission of the reports by the internal committee. Now coming to the another part of this cases in my experience. He has to approach the court, it will take time, and if the case is not and the first day not stated by the court, then he lost his promotion. But in my experience, another hypothesis was raised. In some of the cases came to me that the internal committee members, internal committee members were not cooperating with the complaint at all. So in some of the incidents, I recently, in a case of a armed police force, that internal committee members, including the chairperson, were intimidating the lady, stating that you will be transferred and all. So this kind of incidents are also there. So this lady who actually has made a complaint, means verbal complaint to the chairman of the committee, so he should at least enable her to write a formal complaint. The lady is unable to, she is not known about all these factors and all. Instead of that, the verbal complaint has been taken and a preliminary inquiry was conducted, wherein a staff of a non-NGO, which is not dealt with the sexual harassment and all, which is an environmental organization to Trivandrum, was invited, and the chairperson of the internal committee intimidated this lady that this all are the repercussions of the complaint, and if you want to withdraw the complaint, you do it. In most of the, in my experience, in all the civil officers, officers in civilian nature, there are awareness and the committees are formed, and as per the laid down procedure, this is being done. Still, I have mentioned that this she-box, etc., the officers can install, and the benefits of the same can be done. And I will also suggest another fact that if the committee, internal committee, can suggest that few persons who are experienced in this can conduct a class on this, and from the persons there, if there is any complaint, they can also maintain a register in this regard. I don't know whether a register is maintained. So, so a person who is not, a person is afraid of giving some complaint to against any officer, they can also personally meet the complaint committee chairman, and through a written complaint, she can submit the complaint. So many of the ladies who are unable to submit the committee complaints directly or indirectly, and they are even unable to know that what are the definition of the sexual harassment and what kind of formalities to be followed. So without a formal written complaint, there cannot be any action against anybody. If a person is unable to submit their complaint in writing, the committee formed in any office, they should assist them. So even their female or male colleague, irrespective of any condition, they can help that person who was suffered this sexual harassment to write a complaint against any of the officers, or if the matter is genuine, the colleagues should give her all the supports. So another important fact is that due to procedural irregularities in the committee, many of the cases coming before the courts are forced to stay the proceedings and either remit back the matter back to the department or quash the entire proceedings. So many of the things I have noticed that this procedural irregularities are written large, and even for a preliminary inquiry, the copy of the preliminary inquiry report is not given to the person concerned. So in short, there are 3-4 important factors to be noted. First of all, the person who suffered the sexual harassment should submit a complaint in writing. There is no form of submission of any complaint in the form of a verbal submission, even though the allegation was real and the person failed to submit a complaint in the form of writing, and even if she discussed with her seniors or colleagues, there should be a written complaint. And if the lady or the officer concerned or the staff concerned is unable to submit her complaint due to any difficulties, the colleagues should help her out. Secondly, regarding procedures, preliminary investigation is a must part. Previously, it was only a direct inquiry into the allegations. Preliminary inquiry is now being conducted for 2 reasons. One, if the allegation is false, then the committee can find the fact that this allegation is fact. So there is no need for drawing a regular departmental inquiry proceedings against a person against whom the sexual harassment is alleged. Secondly, if there is a fact, then also they can also recommend for disciplinary action. Then the regular inquiry is being followed as per the departmental norms laid down in each and every departments. So in all the regular departmental inquiry, there will be preliminary hearing, thereafter examination of witnesses, and there will be cross-examination, and also there will be defense witnesses, and finally presenting officer's brief, then this final report. Final report also needs to be supplied to the delinquent as well as to the person who made the complaint. This is an important factor. So the person who is not agreed with the recommendation of the committee that the charges are not proved or there is no charges at all, then also the person who is agreed with the order can also file an appeal under section 18. There is a provision also, and also they can immediately within 30 days they can also approach the concerned court also, normally high courts. So many of the departments have seen that the copy of the final inquiry report is not being supplied, and on the other hand also, in other cases, many of the complaints, even at the stage of the preliminary inquiry or at the stage of even completion of the normal department inquiry, the complaint copy is not served to the delinquent. It is stated that there is a complaint and you just come to the office for an inquiry, and preliminary inquiry is over, there is a charge sheet. Even at the charge sheet level, this complaint is being exposed to him. That is a wrong procedure. The delinquent officer or staff also entitled for a copy of the complaint so that he can know that what is the actual complaint, what is actually transpired. So procedural irregularities are being dealt by the court as important loopholes and for staying the orders or even setting aside the orders itself. And recently in HEMA committee report also, another question arose before the division bench is that whether a person who is seeking an employment can come to the purview of this act. And even a wife of an officer, suppose there is a complaint that wife of a staff or employee suffered sexual harassment at the hand of a person, whether it comes under the purview of this act. No, because there is no employer relation between wife of the person alleged to have committed this act or the employer. So since there is no employee-employer relation, there cannot be any provisions of this act applicable also. In HEMA committee report, the High Court of Kerala has verbally observed that no job seekers also can invoke the provisions of this act. So this act is only covered by the employer and the employees of any organization. It is even extended to the domestic workers also, but there should be a contractual relation, at least a contractual relation should be there. So without which you cannot make a complaint or there cannot be any inquiry also. So Government of India has given ample provisions for even punishing the persons with the purview of this act and also the disciplinary proceedings of each department. So genuinely if a complaint is made, then the perpetrators and the person who have committed the act should be punished. So by following all the procedures laid down, only they can act. That is all the natural justice violations should be effectively taken by the courts to grant stay. So the committee and the committee who are conducting regular inquiry or the preliminary inquiry should make a point that procedure laid down and the opportunities to be given to the delinquent employee should be maintained. So if it is not made for, even in some of the cases I have seen that only for the purpose of assisting the other party, they have not followed the case. That is also coming to notice. So there should be a class for the committee also by any other experienced persons. What are the procedures to be, and they can conduct also mock inquiries also they can conduct, and mock final orders or mock orders can also be submitted before the authorities so that they can also rectify the ways they are committing the errors and all. So by this, can I stop the speech and any questions you can ask? Please, madam.
You said that copy of the complaint has to be given.
Yes, madam.
I read somewhere that court had passed an order around 2020 that in some cases that need not be shared with the complaint because it may be of a nature
I'll explain.
that she may have described in detail.
I'll explain. If you are not giving a copy of the report, then what will happen is that the disciplinary authority will have to relay the report of the preliminary inquiry officer in making the charge. If so, if the preliminary inquiry officer or the committee's report has been relayed by the disciplinary authority to make or draft the charge or even if he is relaying the report in the final order, then this report has to be given. This is in violation because, my lord, madam, this has been in Kerala High Court also 2-3 cases. What is the harm in giving a copy to the other party? Because the other party also needs to know that what is the actual act committed by the other party. Then only destruction. How can it be? So for the intimidation, all there are sufficient protection.
Ways to be misused, like we don't publish the name. Sometimes the details of the act are so such that if it is shared with somebody, as you said,
Then yes, then he has to suffer the consequences. There is ample protection for the this publication of this act and all. So there cannot be. When a complaint is made, suppose there is a false complaint, without knowing the context of the how can I make a representation against? I am also directed by the committee to present my case. What is your explanation? How can I make a representation without knowing, at least knowing by the context?
in all fairness, it has to be against the other employer.
Other employees also, because only when even if suppose there are a lot of matters there false complaints are made, so I have to make my stand clear before the preliminary inquiry committee, because it needs not to be drawn to the regular complaint proceedings. Yes. Yes. Yes, 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 yes.
Suppose the second query is if the complaint is proved to be false, then what was the next course of action the committee should take? Suppose the false complaints are in the inquiry, it's been proved that complaint is false.
Relevant question. If the committee has a case that the findings in the findings that it is a false case, they can recommend action against the person who filed the complaint. So disciplinary action alone on the ground they can take. On the basis of the recommendation of the committee, the disciplinary authority can issue a charge sheet to the concerned person for making false allegation under the provisions of concerned disciplinary proceedings, not under this act.
So can any IPC provision changing can be
IPC is now on now. So for filing a false complaint, you need to file defamation only, because what is the other provisions? Suppose there is a false complaint, and even there is another provision that if the preliminary inquiry report is stated to be given a false report, then also the other party can have a chance to represent. Suppose 2-3 evidences were not taken into account, she can give the evidences list afresh. New evidence also can given, and finally in 2-3 cases there was another action also in a transfer case which was coupled with the sexual harassment case. The transfer was denied and another angle of sexual harassment was fitted, and unfortunately or fortunately, whatever it may be, the court has recommended action against employee. So department has taken severe action transferring it against the person who has preferred a false complaint also. And in the final stage also, if the regular inquiry report it is false, then also you can apply under the provisions of 18. And there also, if it is false, then strict only by way of a strict action by the disciplinary authority to a person who preferred a false complaint, genuine complaints will come out. As I mentioned earlier also, suppose a person is on the verge of promotion, a crucial moment, something will come like that. So for that purpose, giving a copy of the complaint and also the reports to the person who made the complaint also, it is just made transparent. So only, yes ma'am.
I would just like to add, a not proved case cannot be saved as a false complaint. So false complaint.
I will also explain. I will also explain.
A not proved case may not be a false complaint.
Now I will explain that point also. A false complaint, in most of the cases where the committee is of the opinion that it is a false case, then the false case also comes under the purview of not proved, because the inquiry officer is unable to prove. That is the point, na? So even still, if the disciplinary authority is the opinion that the case is proved or the case can be proved, then you can give a disagreement not and case can be proved.
Sir, in most of the cases of sexual harassment, what is evidence?
That is another yes, that is another important.
Very
I am coming to that point also.
Likely that it can be proved always, so it need not be a false case.
Fortunately or unfortunately, the area of evidence to be analyzed in the departmental proceedings are entirely different from that of the criminal proceedings. So the preponderance of probability is the angle you have to look into. If there is any chance, suppose something has happened inside the office, then what will? So all this, recently there was a complaint, a lady complained against a physical assault, but there is no camera, nothing, and even she had not made a complaint also. The colleague said that this was correct. So by way of what to say, for making all these things, CCTVs are I think established in most of the offices and all. It is a protection for the officer also, because false complaint can come up at any time. Any other clarifications?
I wouldn't like to believe the men are only here to make sure there are no false complaints. I would have expected more questions on how to assist the aggrieved person as well as she's not able to file a complaint. What is the duty? I have seen in many cases, as sir just pointed out, criminal inquiry is conducted to make sure that no evidence remains and to keep whatever little evidence is there. She is an outsider, she is a contingent employee, whereas the accused person is our own employee. How can an outsider file a complaint against our employee? That is the attitude which many of us are having, should not be accepted at all. That was the thing.
For that purpose, one thing can be added. Suppose a contingent employee has to file a case against suppose a commissioner like that. So if the committee constituted is by the officers here, she can also submit an application to constitute a committee from outside office also. That is, district complaint committee is for local committees who are having other setups. That is not for the central government office and all. Where less than 10 number of persons are there. Even for a textile shop, there is committee, local committee. Everywhere this is there. But still, as pointed out, this is happening every day.
Outside committee means the case will be handled by a separate committee.
No, it is not outside committee, it's a local committee.
In the case of a contingent, does it want the current ICC?
She can ask for a member or presiding officer from outside officer, any of the officers. Your own officers, any officers.
Another member will be co-opted by
No. The committee will be, separate committee will be there, consisting of the presiding officer of that office.
So this ICC will not handle that.
No. For that purpose, the appellate authority has to be approached and the reasons to be remitted. Then again, there are provisions.
Practically, where is the wherewithal with the contingent employee to have another?
That is important question. There is even no knowledge to her, to whom she has to make a complaint and all. That is a fact.
There lies the support which we need to keep.
Yes, that is the underlying factor. All of us as supervisory officers have to ensure that anybody comes with a complaint, anything you see or
Important
hear,
point.
it should be taken to the logical conclusion. Ask her if she wants to complain. Assist her in making a complaint. It is not a very senior officer that a contingent employee may complain against. It may be the contractor, she may complain.
Maybe against her own colleagues.
Maybe against the colleague, especially when the aggrieved person is of a lower category in the hierarchy. One has to be very careful to provide all assistance.
I think that you have to, I mean, you need to create more awareness. The she-boxing and all, and most of the people would be doing it. So,
Awareness also with us who are in control as to what is to be done in such a situation. So, we are planning some more program. Yes.
Even for contingent employees, contractual laborers also, you can make a workshop for this. That can be in Malayalam also, in local language also. Yes. So that they are in a position to understand. There is a mechanism to prevent this.
So precisely that would cause in certain scenarios where people were attending exactly the department, we employ people who were just across the age of 18.
Yes.
Might be the department who would not even know what would amount to sexual harassment.
Yes.
Because of the inherent biases they would have faced elsewhere, they would say, okay, this is regular routine. such sessions, ma'am, if we can. Ma'am, not even sessions, like I often believe like a one-to-one, say, we had a session on mental health in the first paper. People get to know if we have a mental health issue only when there is a one-to-one conversation that happens within the organization. Something of that sort where a person, in-house person who we can maybe have a contract with or someone who can regularly meet one people who might
at least made it known that there is a committee existing for the purpose. He can come to the office and share all these things.
Sir, any such best practices we have seen in other departments?
In other departments, this tea boxes I have not seen anywhere, and even committees. No, you have to establish it, no? One in your office. So I have not seen actually the notice or expressing that here is a harassment committee is there, internal committee is there. I have not seen any notice to this effect. No, I am not talking about she office notice. This is about you have to portray that here is a committee. There is no. It has to be portrayed in somewhere in the office, and the details of the office bearers also to be given. No, the awareness about the student portal has to be given. That is what I meant. It is not like the physical box is there. And even as you was telling, even you can keep a complaint box also in the office for submitting a complaint by the contractual laborers and all. So if there is no other questions, I'm stopping.
I think she was asking. Thank you, sir. Thank you for your valuable insights. Next, for the concluding comments, I invite respected Principal Commissioner of Income Tax, Srimati Uma Venkateshan ma'am, who is also the chairperson for the Internal Complaints Committee, Kochi and Trivandrum. Ma'am, please.
Respected Madam Preeti Garg, Principal Chief Commissioner of Income Tax, Kerala, Sri Sanil Kumar ji, Advocate, Kerala High Court, colleagues and friends. This session by Sanil Kumar has actually given us a total overall view of this Prevention of Sexual Harassment at the Workplace Act, and which was extremely needed by all of us here. There are so many youngsters who have joined the department who really do not, they are coming from various backgrounds, and because of the way they have been brought up, I'm not saying that there should be any mistakes in their upbringing, but they may not be aware of what is constituting a sexual harassment, and there may be instances where they may unknowingly, because of the gender stereotyping that they have gone through in their if there is a patriarchal system in which they have been brought up, most of our youngsters may unknowingly fall into this, like they may unknowingly harass their colleagues. So it is extremely important. In fact, I was trying to message that all our officers, all our staff members should be mandatory, madam, I would say mandatorily made to attend such a course. Only then will they understand what is expected of them, how they are expected to work, to behave in a workplace. They may think, they may come from a college environment where teasing each other, etc., is, maybe they think it is a joke, but it is not so in a working environment where all of us are expected to work professionally, and there should not be an iota of gender bias or gender stereotyping which would eventually lead to sexual harassment. So this is my take on this, that all of us, we should educate our youngsters. We have a lot of youngsters here. Let us as officers, we take it upon ourselves to educate the youngsters who have joined the department to understand what is gender bias, gender stereotyping, which eventually leads to sexual harassment. Am I right, sir? Isn't it that we start with gender bias and then we move on to gender stereotyping, and then we fall into this trap of sexual harassment? And here again, what sir said about, advocate said about the, gender, all of us, like, it should be that we should, in my opinion, not remember even what is the gender of the person with whom we are working. We should always work as equals. If somebody is sitting with me, or if others are sitting with each other, we are all equal here. Why are we thinking of it is a woman or a man? Let us think of the work. If that is the attitude in which we are working here, I am sure eventually, or I am sure by and large, we are okay in the department. We do not have much cases, and probably a little bit of gender bias would be there, which at this stage itself, if we are going to nip it in the bud, we will be able to maintain an equal working environment for all of us. So I would prevail upon the senior officers and friends here to make it a point to probably ensure that all the youngsters working with them are taught what is important when they come to work here. And regarding the seniors, it is for them to understand that they have already worked so many years in the department. They have all worked together. We have all worked equally. We have worked shoulder to shoulder. Let us retain this equality amongst ourselves. Let us remember that just as we have the right to work here, similarly the other person, whether he is a man or a woman, whomsoever he may be, has equal rights to work here, and it is our duty to ensure that he feels or she feels that she is given due respect and due regard, and only her work and only merits count. I think with these few words, I thank Mr. Sanil Kumar sir for giving this overview of the Act, which was very important to me, because I may require your help, sir, to understand the legal aspects of this if at all I have to deal with the case, which I hope I don't have to deal with. I request that all of us, with our conduct, we ensure that I do not have work to do. Me and the committee do not have work to do. But that does not mean that if complaint comes, I am not going to welcome it. If a complaint comes, I shall take it up in full measure, and it shall reach its logical conclusion. With these words, I thank you for this.
Thank you, ma'am. Now I request Srimati Preeti Garg ma'am to please felicitate our guest for today, Advocate Sanil Kumar sir, with a memento. Lastly, I invite respected Assistant Commissioner of Income Tax, Srimati Shritu ma'am, to deliver vote of thanks.
Good evening, everyone. Respected Principal CCIT Preeti Garg Madam, Uma Venkateshan Madam, Speaker of the Day Sanil Kumar ji, other seniors, colleagues and friends. A safe workplace is like a puzzle where there are different components, and each component is important and all the voices matters. As a prelude to this, we have organized this workshop on Prevention of Sexual Harassment Act, and now we have came to the end of this session. First of all, I wish to express our sincere gratitude to Srimati Preeti Garg Madam, Principal Chief Commissioner of Income Tax, for joining us today and addressing the gathering. As Vani Madam already said, Madam always motivates and encourages us to arrange different sessions which will empower our manpower to bring the best out in them. So we already had a session on mental health, and now we are having a session on this POSH Act, and many more things are coming up. Thank you, Madam, for your guidances. Sincere thanks to Uma Venkateshan Madam, Chairperson our Internal Complaints Committee, for addressing the gathering and sharing your words of wisdom, ma'am. Thank you, Madam. On behalf of our department, I wish to extend our sincere gratitude to Sri Sanal Kumarji, Senior Advocate in High Court of Kerala, who took his valuable time to conduct this session. Sir took his sincere effort to make each one of us an informed citizenry regarding our rights and responsibilities under the POSH Act. Thank you, sir. I wish to take this opportunity to thank the hands behind the curtains in organizing all these sessions. Sincere thanks to Sri Shankar Prasad sir, CIT admin, and Veniraj Madam, additional CIT, for organizing all these sessions and supporting in each and every part of it. Thank you, sir, madam. And special mention to the team, Kumar Gaurav, ITO PR, Vivek, our OS, and all the PR team who put their sincere efforts in all these functions. We are just seeing like somewhat 1 hour functions, but there are works of hours and hours behind all these functions to arrange it, to coordinate it, and to bring it at our level best to each one of you. So the team, you are the best. Thank you. And I just want to reiterate that if any of our lady employees faces any kind of issues, you can confidently and freely approach our Internal Complaints Committee, and we all are here to help you out. And your silence will not protect you, but your voice will definitely empower you. So finally, I wish to extend our sincere gratitude to each one of you who had actively participated in this session, both offline and online. Let's work together to make a safe workplace. Thank you.
Thank you, ma'am. As we conclude today's event, I want to thank each one of you for your participation and commitment to creating a safer workplace. Let us all remember that preventing sexual harassment is a continuous effort that requires all of us to take action. Thank you once again to our eminent guests, officers, and staff who are present here today. Together, we can foster a culture of respect and safety in our workplaces. Thank you.